Hello everyone, this is Gaston Crew for this week's Markman Minute. You can find our content at mimesiswebtv.com. For this week's video, I wanted to talk about an interesting situation that I think brings into real effect the changes in patent litigation that we've seen over the last couple of years. I alluded to it in this week's Markman note, which you can also find at mimesiswebtv.com. And what I thought interesting was a case that was brought by a large patent assertion entity called Acacia, happens to be publicly traded under the ticker symbol ACTG, against a non-traditional patent defendant in National Oil Well Varco, or NOV is the stock ticker symbol for that one. What makes this case interesting to me is that I think it's reflective of a few trends that we're seeing in the industry. First of all, there's been a premium lately on patent assertion entities like Acacia finding targets a little bit more outside the traditional scope of targets that they've targeted in the past. So while Acacia has for many years filed a lot of cases against technology companies like Google or technology companies like Sony, now you're starting to see patent holders looking for targets in less traditional industries like oil and gas. So for one, I thought it was interesting to see that Acacia had initiated this case against National Oil Well Varco. Probably more interesting, though, is the response that they got. Because of things like inter partes review, which is a procedure in the Patent Office that we've addressed in the past, defendants today are a lot more emboldened than they were even 3 or 4 years ago. When we used to work in a large firm, there was always a sense that no matter how successful we would be in defeating a patent challenge brought against one of our clients, it was going to cost our clients a lot of money to defend the case, usually in the 7 figures. And what that did was create an environment where there was a lot of money to be made for patent assertion entities who could leverage the high cost of litigation against corporate defendants and convince them that, yes, you could litigate and you might beat us after a few years, but you'll spend millions of dollars in the process and you'll have a lot of business disruption. Or you could pay us a few $100,000 today and the case goes away. And by and large, that happened a lot, and it made the patent assertion industry a very lucrative one. Nowadays, though, the paradigm has shifted a bit, and companies like National Oil Well Varco, which doesn't seem to be the target of dozens of patent lawsuits like a Google might be in any given year, can now look at the IPR process as almost a first-line defense. And looking at the interplay in the case filed by Acacia, it's really interesting to see. The case itself in the district court hasn't really gone anywhere. It's actually, the last thing I saw on the docket was a transfer from the Eastern District of Texas, which means Marshall Tyler or Texarkana, over to the Southern District, which would probably mean the case would end up in Houston. But basically nothing substantive has happened in the case. But what has happened is almost a year has gone by. The parties have obviously not settled. And a sophisticated company like National Oil Well Varco said, instead of paying Acacia what they're asking for, we may as well take this patent that they're using against us and challenge it in the patent office. And that's exactly what they've done. And it looks like they've gotten the petition for inter partes review in within the 1-year limit, because you have a year from when the complaint was served on you to file your inter partes review. And I think it's just another sign of how inter partes review practice is changing patent litigation for publicly traded companies. Last week we talked a little bit about how it's being used by Kyle Bass as a way of supporting a short position in pharma companies. And now I think we're seeing how even a non-traditional patent target like National Oil Well Varco in the oil and gas industry is using it to stare down one of the most experienced patent assertion entities there is out there, and one of the largest. And so it's going to be interesting to see, obviously, how the case develops. I would expect that National Oil Well Varco would ask the district court to stay the case pending review of the IPR. And by and large, companies have been successful in doing that. But more generally, I think this situation speaks to the broader trends in the patent litigation market, which are, patent assertion entities are looking for non-traditional targets. Patent defendants are a lot more emboldened and using the IPR process in order to take a little bit of the initiative back once they've gotten sued. And I think it's also reinforces the need for investors to keep an eye on patent proceedings in parallel tracks. You not only have to follow a district court case, but you also have to keep your eye on the patent office nowadays as well. That's it for this week's Markman Minute. Please catch us on mimesiswebtv.com, and feel free to get back to us with any feedback or comments. Thank you. See you next time.